I'm going to do is understand Mr. Pickering's concerns, draft up a letter saying, as I understand it, you're complaining that your lawyer is failing to communicate, or whatever the concerns come out when we chat, and then ask him to sign that and send it back. Okay. At that point, I have lots of options.
Let's do that.
At that point, I have lots of options. I can ask the lawyer for his side of the story. I can decide that this is not a matter that the bar has jurisdiction over. Whatever I decide at that point, Mr. Pickering will be advised of our decision. And so with that as background, what I've heard so far, Ben, is that you don't think your lawyer is communicating with you very well, and you feel that the lawyer is neglecting your case. Is that it?
Yeah.
And do you have some examples of why he's not communicating and why you think he's neglecting your case?
If you looked at the phone records of attempted calls, we've got unanswered messages to 4 persons because it's gotten so bad I've had to go to Lane Borg and Miss Dunn in terms of, okay, well, let me speak to a manager. Why is it Ben can never talk with his lawyer? And I've been told, like, his advocacy needs have been violated in the sense that they've tried to shut me out of meetings on multiple occasions, as well as tell me that I can't inform them of his medical accommodation needs. And then I've actually been hung up on by an assistant, which is an assistant, not a lawyer. I understand that. But it's a part of the bad overall customer satisfaction experience. And then in terms of whatever agreement that Ben signed straightforward, we haven't been able to get information as to why he was appointed Tom Borton, why Tom Borton was then suddenly fired after we'd spilled our guts to Tom Borton. Then it seemed, and then also Tom Borton spoke to Greg Kafuri on the potential for a civil police brutality litigation, and I'm concerned that Tom Borton has sabotaged Ben. I mean, that might be a separate matter, whether or not they've also sabotaged his chance for civil justice.
Yeah, so Mary, these are all separate matters.
Okay.
Because the Oregon Rules of Professional Conduct require lawyers to communicate only with their own clients, and shutting you out of these meetings is probably something they're required to do, because if they allow you to attend these meetings, then that violates the attorney-client privilege. So they're actually complying with their ethical obligations by not communicating with you or not letting you attend the various meetings. But the issues that I will be able to look at or consider are the communication issues. So Ben, can you give me some example? I mean, I've heard that you've got phone records of many messages you've left without return calls. Are there any other examples? Have you asked them for information about your case that they haven't explained?
I thought attorneys or lawyers were supposed to, talk to their clients, like, not wait. I mean, I don't understand what the waiting deal is, or why I can't contact them, or what they fill me in on what's going on, or even give me anything for, like, what's the deal? I don't know. I don't understand it. Well,
yeah, so I'll read the rule to you. So Oregon Rule of Professional Conduct 1.4 says a lawyer shall keep a client reasonably informed about the status of the matter and comply with reasonable requests for information. So it's a little tricky when it's a court-appointed lawyer, because they're limited to only dealing with defending you from the criminal charges. So, for instance, if you called and said, I don't understand why I've been charged with XYZ offense, they would probably have to discuss that with you. But if you called and said, I want to know what I can do about the police brutality, they're under no obligation to discuss that with you, because that's not part of their representation.
Okay, yeah, I'm just wondering.
Do you have some examples of, asking them for information about your criminal charges that they failed to
exactly.
Yeah, exactly.
Yeah, and we've asked for them to be mailed to our address on record in a disability suitable format, which I think a reasonable communication includes reasonable accommodations for the traumatic penetrating brain injury, which was aggravated by the police assault. I understand the civil and criminal distinction, but Ben's lack of comprehension, the issue with the medical fragility is that Ben is not allowed to go out in the world and get his feet up from bed rest due to the severity of the TBI, and they refuse to understand that. So,
Sure. So how do they communicate with him? Do they talk to him on the telephone? Do
No.
they meet with him at court
No,
appearances?
they haven't contacted me doing anything yet.
They've never contacted you've never talked to your lawyer. And so how have they communicated with you?
They haven't.
Well, you know that you have a lawyer, so there must have been some sort of communication.
Oh, I seen her in court. All she said was, "You don't have to show up for the next hearing. I'll deal with it." Blah blah.
Okay, so you have met with your lawyers, and
Yeah,
they've
but
talked.
she's not filling me in on what's going on, anything. She just said, "Don't show up for court." So what's that mean?
Well, I guess it means don't show up in court. But what's the difficulty with that?
well, and one of what I was understanding is that prior to my becoming involved with Ben's case on 628 as an advocate, they were attempting to force him into a plea bargain where he admitted guilt on the drummed up charges, the assaulting officers. And so they had coerced him, taken him into a back room and tried to get him to sign guilt. I got involved, and then I started calling, was able to make them aware that he has a left eye, which is blind, and a right eye, which reads dyslexia, in the right to left, and that
Right,
his...
but Mary, how does that affect an in-person meeting?
How does it affect?
Yeah, if they were meeting with him in person, how does his disability make that an issue?
Are you familiar with traumatic brain injury?
No,
Penetrating?
that's why I'm asking. I guess what I'm asking is, as I understand it, he has a disability that affects his ability to read stuff. But if he has an in-person meeting with his lawyers,
Oh,
how
well,
is
you
it?
must never have had an eye blinded and your skull crushed open. Because the thing is with traumatic brain injury, sometimes it's very difficult to understand things.
Okay, I get that. So what are you suggesting that they do other than meet with him in person or write to him?
Well, for instance, automobile travel is very extremely stressful, especially with heat is very aggravating for the extreme headaches that occur. And while you may just think, oh, it's easy for you to play phone tag, call their office 26 times, beg to get an appointment, get denied, get put off onto voicemail after voicemail after voicemail. It's extremely draining when we also have a host of doctor's appointments and the lawyers are playing hooky on
Mary,
his
you don't need to explain that to me. I completely get that, but what I'm hearing is that they've actually had in-person meetings with Ben. Is that not the case?
No.
No, and
They haven't met with you. Okay, not even in court.
No. When I went to court to one of my hearings, they're like,
Yeah.
"Well, you've been assigned to this person." Well, she's like, I don't know who she is, but she just says, she didn't explain much. She just said, I was like, "Well, what's going on with anything?" She didn't want to tell me. She just said, "Don't show up for court on the 15th," and I was like, "And we'll handle it." I'm like, "Huh?"
And because Ben couldn't
I don't
understand
know what's going on.
the
And then
paperwork.
Yeah.
They hung up on us one of the times that I've called when I complained that they refused to admit Ben's blind needs or his TBI needs. I mean, is that recommended, that they can ignore his medical needs, and then when I try to establish his medical needs, that they treat me rudely and isolate us?
Well, professionalism would suggest that they don't treat you rudely, but there's no rule of professional conduct that covers that sort of behavior.
Can I rewind a little?
But what I'm hearing is that you've had essentially no contact with your lawyer. They haven't met with you. They haven't written to you. They haven't talked to you on the phone. They haven't advised you of anything, and you don't understand what the status of your case is.
Yes.
Okay. So tell me about the neglect matter. So have they failed to show up at hearings? Did they miss a trial? Did they not get discovery? What is it that you feel they've done or not
could you
done
explain to Ben what discovery is?
Yeah, discovery of the police reports.
But also the discovery will be the medical records regarding the head injuries?
Well, no, discovery is the material that the lawyers would get from the opposing side. What they choose to get from their own client, that's a strategic decision left to the lawyer's determination. But the way it usually works, okay, and I can only say the way it usually works. Now, what county is this in, by the way?
Multnomah.
Okay, so the way it works in Multnomah County is the prosecutor's office gathers up the police reports and either leaves them someplace at the courthouse where the lawyer can get them, or they simply mail them to the lawyer. So whatever it is the state has, whatever it is Multnomah County has, they would provide to your lawyer. That's discovery. Whatever they choose to get, whether they hire an investigator to go interview witnesses, whether they obtain your medical records, that's all part of their investigation, and they get to decide what they think is important to that. Obviously, you can tell them what you think is important, but it's the lawyer's job and responsibility to decide if it is or isn't.
And then, can you tell me, in terms of the prosecutor is the DA, are we able to know who the exact person is who is the DA?
I think it's public record.
Public record. So just look that up, and I could possibly figure out who's launching this prosecution. Also,
you may be able to, Mary, but you got to understand that these things are fluid. So let's say Joe Blow is listed as the prosecutor, and you arrive for a trial. It may be Mary Blow.
Okay. And then also, will the officers who attacked Ben be forced to come to trial to say why they attacked him?
Well, by forced, I'm not sure what you mean.
Well, will the case be dropped if the cops don't show up?
I can't answer a question like that. All I can tell you is the state has to prove its case. Whatever it takes to do that, that's the state's problem.
The state's problem. Yeah, okay.
Yeah,
and then my other question was rewinding back to this whole public defender process. I apologize for my ignorance. In terms of Ben getting a court-appointed lawyer, that was because he was indigent.
Uh-huh.
And did he have any other options? And
sure, he could hire his own lawyer.
Right. And so he was not explained his options when he was forced to sign up for a defender?
I'm not sure I understand your question. So did he advise the court that he could not afford a lawyer?
He was in shock from the police brutality, and he doesn't understand what's going on.
But my question remains, did he ask the court for a court-appointed lawyer?
He says no. He's shaking his head no.
You didn't ask the court for a lawyer? You can afford your own lawyer?
Well,
they just said we're going to court appoint you a lawyer, but I